We are today starting the program with a recitation of Quran and Surah Yasin. The recitation of Surah Yasin today is following the passing of Brother Zain Sikafi's father in Iraq. So let's start with Surah Yasin.
أعوذ بالله من الشيطان الرجيم. بسم الله الرحمن الرحيم. ياسين والقرآن الحكيم إنك لمن المرسلين على صراط مستقيم تنزيل العزيز الرحيم لتنذر قوما ما أنذر آباؤهم فهم غافلون لقد حق القول على أكثرهم فهم لا يؤمنون إنا جعلنا في أعناقهم أغلالا فهي إلى الأذقان فهم مقمحون وجعلنا من بين أيديهم سدا ومن خلفهم سدا فأغشيناهم فهم لا يبصرون وسواء عليهم أأنذرتهم أم لم تنذرهم لا يؤمنون إنما تنذر من اتبع الذكر وخشي الرحمن بالغيب فبشره بمغفرة وأجر كريم إنا نحن نحيي الموتى ونكتب ما قدموا وآثارهم وكل شيء أحصيناه في إمام مبين واضرب لهم مثلا أصحاب القرية إذ جاءها المرسلون إذ أرسلنا إليهم اثنين فكذبوهما فعززنا بثالث فقالوا إنا إليكم مرسلون قالوا ما أنتم إلا بشر مثلنا وما أنزل الرحمن من شيء إن أنتم إلا تكذبون قالوا ربنا يعلم إنا إليكم لمرسلون وما علينا إلا البلاغ المبين قالوا إنا تطيرنا بكم لئن لم تنتهوا لنرجمنكم وليمسنكم منا عذاب أليم قالوا طائركم معكم أئن ذكرتم بل أنتم قوم مسرفون وجاء من أقصى المدينة رجل يسعى قال يا قوم اتبعوا المرسلين اتبعوا من لا يسألكم أجرا وهم مهتدون وما لي لا أعبد الذي فطرني وإليه ترجعون أأتخذ من دونه آلهة إن يردني الرحمن بضر لا تغن عني شفاعتهم شيئا ولا ينقذون إني إذا لفي ضلال مبين إني آمنت بربكم فاسمعون قيل ادخل الجنة قال يا ليت قومي يعلمون بما غفر لي ربي وجعلني من المكرمين وما أنزلنا على قومه من بعده من جند من السماء وما كنا منزلين إن كانت إلا صيحة واحدة فإذا هم خامدون يا حسرة على العباد ما يأتيهم من رسول إلا كانوا به يستهزئون ألم يروا كم أهلكنا قبلهم من القرون أنهم إليهم لا يرجعون وإن كل لما جميع لدينا محضرون وآية لهم الأرض الميتة أحييناها وأخرجنا منها حبا فمنه يأكلون وجعلنا فيها جنات من نخيل وأعناب وفجرنا فيها من العيون ليأكلوا من ثمره وما عملته أيديهم أفلا يشكرون سبحان الذي خلق الأزواج كلها مما تنبت الأرض ومن أنفسهم ومما لا يعلمون وآية لهم الليل نسلخ منه النهار فإذا هم مظلمون والشمس تجري لمستقر لها ذلك تقدير العزيز العليم والقمر قدرناه منازل حتى عاد كالعرجون القديم لا الشمس ينبغي لها أن تدرك القمر ولا الليل سابق النهار وكل في فلك يسبحون وآية لهم أنا حملنا ذريتهم في الفلك المشحون وخلقنا لهم من مثله ما يركبون وإن نشأ نغرقهم فلا صريخ لهم ولا هم ينقذون إلا رحمة منا ومتاعا إلى حين وإذا قيل لهم اتقوا ما بين أيديكم وما خلفكم لعلكم ترحمون وما تأتيهم من آية من آيات ربهم إلا كانوا عنها معرضين وإذا قيل لهم أنفقوا مما رزقكم الله قال الذين كفروا للذين آمنوا أنطعم من لو يشاء الله أطعمه إن أنتم إلا في ضلال مبين ويقولون متى هذا الوعد إن كنتم صادقين ما ينظرون إلا صيحة واحدة تأخذهم وهم يخصمون فلا يستطيعون توصية ولا إلى أهلهم يرجعون ونفخ في الصور فإذا هم من الأجداث إلى ربهم ينسلون قالوا يا ويلنا من بعثنا من مرقدنا هذا ما وعد الرحمن وصدق المرسلون إن كانت إلا صيحة واحدة فإذا هم جميع لدينا محضرون فاليوم لا تظلم نفس شيئا ولا تجزون إلا ما كنتم تعملون إن أصحاب الجنة اليوم في شغل فاكهون هم وأزواجهم في ظلال على الأرائك متكئون لهم فيها فاكهة ولهم ما يدعون سلام قولا من رب رحيم وامتازوا اليوم أيها المجرمون ألم أعهد إليكم يا بني آدم ألا تعبدوا الشيطان إنه لكم عدو مبين وأن اعبدوني هذا صراط مستقيم ولقد أضل منكم جبلا كثيرا أفلم تكونوا تعقلون هذه جهنم التي كنتم توعدون اصلوها اليوم بما كنتم تكفرون اليوم نختم على أفواههم وتكلمنا أيديهم وتشهد أرجلهم بما كانوا يكسبون ولو نشاء لطمسنا على أعينهم فاستبقوا الصراط فأنى يبصرون ولو نشاء لمسخناهم على مكانتهم فما استطاعوا مضيا ولا يرجعون ومن نعمره ننكسه في الخلق أفلا يعقلون وما علمناه الشعر وما ينبغي له إن هو إلا ذكر وقرآن مبين لينذر من كان حيا ويحق القول على الكافرين أولم يروا أنا خلقنا لهم مما عملت أيدينا أنعاما فهم لها مالكون وذللناها لهم فمنها ركوبهم ومنها يأكلون ولهم فيها منافع ومشارب أفلا يشكرون واتخذوا من دون الله آلهة لعلهم ينصرون لا يستطيعون نصرهم وهم لهم جند محضرون فلا يحزنك قولهم إنا نعلم ما يسرون وما يعلنون أولم ير الإنسان أنا خلقناه من نطفة فإذا هو خصيم مبين وضرب لنا مثلا ونسي خلقه قال من يحيي العظام وهي رميم قل يحييها الذي أنشأها أول مرة وهو بكل خلق عليم الذي جعل لكم من الشجر الأخضر نارا فإذا أنتم منه توقدون أوليس الذي خلق السماوات والأرض بقادر على أن يخلق مثلهم بلى وهو الخلاق العليم إنما أمره إذا أراد شيئا أن يقول له كن فيكون فسبحان الذي بيده ملكوت كل شيء وإليه ترجعون صدق الله العلي العظيم.
Brothers and sisters, can we all recite the Surah Fatiha for Marhum Dr. Abbas al-Sikafi, Surah al-Fatiha.
Thank you very much, Muhammad, for that beautiful recitation. We're now very fortunate to have Zahra al-Rikabi, who will be speaking to us about COVID-19, some legal implications. Zahra, are you on? Are you able to put your, thank you, and if you put yourself on landscape and your video, that would be great. Thank you. So just a little bit about Zahra. She is a barrister at one of the UK's top chambers, the Brick Court Chambers. Legal 500 said she was in the ascendancy and she was selected for the prestigious Lawyers Hot 100 in 2020. She's frequently instructed in high-profile cases in her areas of practice. Recently, she appeared in Canary Wharf versus European Medicines Agency, the top case in the Lawyers' top 20 cases for 2019. And she's currently instructed in Municipio de Marina, and orsv BHP Group, which features in the Lawyers' top 20 cases list for 2020. She has a broad practice encompassing commercial litigation, public international law, and public law. She's appeared as sole counsel in the High Court and the Court of Appeal. She's also been led in cases before the Supreme Court and the Justice of the European Union. She's acted for a wide range of clients, including states and international organizations. And she's a native Arabic speaker, which makes, as many of us will know, which makes her well placed to deal with any domestic litigation or international arbitration where her Arabic language skills can be used. So we're very, very fortunate to have her here. So let's welcome her. Salat ala Muhammad wa al Muhammad. Allahumma salli ala Muhammad wa al Muhammad.
Thank you very much for that introduction, Muqdad. Assalamu alaikum. Thank you all for taking time out of your evening on a Friday to listen to another law lecture. I don't know how many people in the audience were here last year. I think it was roughly around this time last year when I spoke about public law, general principles of public law. Some of them will be relevant today, but I thought I would pick up on a couple of themes, legal themes that have come out of the recent pandemic. I don't know if you can see the slides. Are they?
Yes, they can be seen. Yes. Anyone who's on Zoom, if you'd like to see them, you can just double click on it. But those on YouTube, the 40 or 50 people on YouTube, you can just see it directly. So that's fine. So please go ahead, Zahra. If you just ask when you'd like the slides to change, we can change them. Are you on mute, Zahra?
Sorry, yeah, I do seem to have muted myself. I mean, everyone who's had to do work Zoom meetings knows how these things go. They're more likely to go wrong than right, but fingers crossed we'll get through this evening. So if we go to the first slide, please. My slides. So I've just highlighted here a number of the many areas of life that are currently impacted by COVID-19. I mean, where law is, the legal implications have changed. So in terms of welfare, the welfare state, insurance markets were significantly impacted. At one point when the restrictions imposed by the government were advice rather than law, were people able to make insurance claims, for example, and did they actually require legal restrictions through the lockdown to enable them to make insurance claims? So there were a number of questions around the insurance markets, issues around tax liability for anyone who chose to defer, for example, their July payment on account. You would be well aware that there's issues around tax liability at the moment that there's all sorts of employment rights issues, and I was actually hoping to have an employment lawyer join me this evening to talk specifically about employment law, because I don't, it's outside my area of practice, but unfortunately she's in trial this week, so she wasn't able to join us. So the two boxes I've set out on the slide that are actually in red are the two areas that I'm going to touch on this evening. So I've got restrictions on personal liberty through the lockdown regulations and frustration of commercial contracts. So it's slightly two different areas of my practice, so commercial and public law, but I thought it'd be interesting to mix it up a bit and touch on two quite different areas of law. But I'm quite keen to sort of have a discussion afterwards. So I'll try not to be too long. Miqdad, could you please just remind me how long the session goes on for, just so I can keep an eye?
Half an hour or so.
Okay, so I'll keep an eye on the time, inshallah, and I won't overrun. If we can go to the next slide, please. So through the various different regulations we've had over the last few months, starting from March really, there's been a number of restrictions on our personal liberty that have taken place, and they've been of varying degrees really. At the height of the lockdown, there were restrictions on having seen people indoors, on personal contacts, essentially, on being able to leave the house, how many times you can leave the house, what you can do when you leave the house. And one of the most pertinent things during that period is the extensive use of guidance to explain those restrictions and to convey those restrictions. The issue with the guidance is that it often was unclear whether the restriction was actually a legal requirement with consequences, so criminal consequences, you know, a fine, or where there's potential for the police to enforce, and where it was simply public health advice. And so lots of the things that people believed they were legally bound to do were actually simply public health advice, and that the government was repeatedly unclear in the advice that it was giving out and the guidance that it was giving out as to where to draw the line between where it was giving us advice about what to do from a public interest point of view, essentially, that we're protecting our own health and the health of others, and where there was in fact a legal requirement to do something that would be followed with a penalty if you fail to do it. In one of the surveys that was carried out, 99% of the people surveyed claimed to know mostly or exactly what activities were permitted under the law during the first phase of lockdown. But 94% actually got the answer wrong when asked whether intentionally coming within 2 meters of someone outside their home was prohibited by law. If we can go to the next slide, please. What we've seen throughout this period of time since the start of lockdown up until essentially the last regulations that were laid by Parliament is the repeated use of emergency procedure by the government, even in relation to regulations that were in fact an easing of the lockdown. And so the acuteness in the initial decision to bring in a lockdown, you know, the state of emergency, if you like, that could have justified emergency procedure, had shifted by then, but the government had very much got into the habit by, you know, what we could see, what we could observe, of imposing regulations, so law that was binding on the population, sometimes at 10 p.m. at night, shared on Twitter. You know, people were finding out about restrictions to their liberties through very informal means, and then they would be laid in Parliament 2 days after or 3 days after, and this particular pattern that we saw was really quite disconcerting, because these regulations did have an impact on people's liberties. Even, you know, relatively speaking, yes, when you look at other countries where people's liberties were much more severely hindered than the UK, you might think, well, okay, what's the fuss all about? But as a country that is normally governed by the rule of law, telling people what they can and can't do, when they can leave their home, who they can and can't have in their home, is actually really quite a big deal. And so the fact that we were seeing these regulations being laid before Parliament, even if they were subject to the affirmative procedure, which means that Parliament can strike them down, but they were often laid before Parliament after they become law and after they start being enforceable. However, on the 12th of October 2020 was the first set of regulations that we had being laid before Parliament before they came into force. And so hopefully we're beginning to see a change in the government's approach to parliamentary scrutiny. But unfortunately, having said that, it doesn't mean that parliamentarians are actually able to scrutinise the government, because the regulations that are being laid before Parliament are so long and convoluted and complicated that often it's actually very difficult to decipher what they're saying, and it's difficult for Parliament to properly debate them and hold the government to account to make sure that the regulations are proportionate and they're not arbitrary. If we can go to the next slide, please. What we see, in fact, is ongoing confusion about the content of the rules. The Prime Minister, Boris Johnson, just a few days ago, in a press briefing, gave the wrong answer to a really basic question, a really fundamental question to many families, you can imagine. It was a question from a father who wanted to know if he could visit his children who live with his ex-spouse. And so it was a question about, if you move to a higher tier, if the area you live in becomes a higher risk area, would that prevent you from seeing your children? And the Prime mumbled something along the lines of, well, it might and it depends. And the answer to that is no, it doesn't. In fact, being able to see children who live in another home has always been an exception. It was an exception, an express exception at the very height of the pandemic. And so the government's not about to row back from that position. Again, this morning on BBC Radio 4, 2 experts gave the wrong answer in relation to whether it's possible to visit a friend that you believe to be dying, which again is an express exception in the regulations that specify that if you believe that a friend is dying, then that is seen as an exception to the rule, otherwise preventing you from mixing with someone indoors from outside your household. So what we see really is a very complicated national picture in which there are different lockdown regulations in different areas of England. And then the devolved administrations have further layers of rules that they impose within their nations. And so Scotland has different rules and Wales has different rules. And there's been some talk about, in fact, even barriers to entry between different nations, which it's difficult to envisage being enforced. And it's difficult to understand what powers underpin the ability to prevent, British nationals from moving within the United Kingdom. But those are the sorts of headlines we're seeing these days in relation to the attempt to fight this virus as it continues to spread. If we could go to the next slide, please. So you might be thinking, well, okay, why does this matter, really? I mean, in the bigger scheme of things, when there is a deadly virus that we're fighting and lives are being lost, and the number one priority must be to preserve and to look after vulnerable people, why does it matter that the law is such a mess and that the law is so complicated and inaccessible? But it does matter, and I say it matters because one of the requirements of the rule of law is that the law must be accessible and, as far as possible, intelligible, clear, and predictable. In one case for the European Court of Human Rights, Sunday Times in the UK, the Court of Human Rights expressed their principle in this way, that the law must be adequately accessible. The citizen must be able to have an indication that is adequate in the circumstances of the legal rules applicable to a given case. Secondly, a norm cannot be regarded as a law unless it is formulated with sufficient precision to enable the citizen to regulate his conduct. He must be able, if need be with appropriate advice, to foresee, to a degree that is reasonable in the circumstances, the consequences which a given action may entail. And what really this goes to, I think, and why it's important, is that it's a very integral part of having personal autonomy, that you can understand what the legal obligations imposed on you are, and that those obligations are of a nature that makes sense to you, that is clear to you, so that you could shape your life around what those legal obligations are. And then you can get on with your life. Where legal obligations feel arbitrary, where they feel capricious, or where they're simply unclear, and so you don't know how to conduct yourself, it becomes a problem from a personal autonomy point of view. What we see in relation to the current regulations is actually they are so detailed, so complicated, that people then err on the side of following all the advice, not out of choice, but out of fear that they'll get it wrong if they try to figure out what they're legally obliged to do and what they may choose not to do. I looked earlier at the BBC website, so I was hoping to be able to give advice today about what the different meanings mean. But unfortunately, I haven't had time in this last week to read them in detail. And they're very long, very complicated. But I found this search tool on the BBC website, for example, which I share later on, where you put in your postcode and you're then given a list of the rules that apply to you. So it says, you must not leave your house. It doesn't say that, sorry. It says you must not have people from outside your household come into your house, that kind of thing. what's unclear from that list, and what I haven't checked against the regulations, is actually how much of that list of do's and don'ts is actually law. So there is a financial penalty if you break it, and you're breaking the law, and the police can step in and enforce the law. And what percentage of it is actually just advice, that the government is advising you in the interests of your health and other people's health to behave in a particular manner. If we go to the next slide, please. Now, you may or may not have seen that the lockdown rules have actually been challenged in a judicial review. So that's a public law claim, essentially challenging the legality of the regulations. And this is the case of Dolan and Secretary of State for Health and Social Care and Secretary of State for Education. The challenge was against both the lockdown restrictions and the decision to close schools and educational establishments. On the 6th of July 2020, Mr. Justice Lewis refused permission for the legal challenge. And on the 4th of August 2020, the Court of Appeal ordered the application for permission as had together with the judicial review. So when you bring a judicial review claim, you don't go straight to a hearing. First, there is a permission stage in which the court decides whether your case should be heard. And actually, and in this particular case, Mr. Justice Lewis decided that the case shouldn't be granted permission, that there wasn't a good enough legal basis for challenging the regulations. But the Court of Appeal decided that the case is so important that what they will do is they will roll, so they call it a rolled up hearing, in which they decide both the question of permission as well as substance in the space of one hearing. And they basically said, you know, these regulations are so wide reaching and they impact so many areas of life that the question of whether they are lawful should be decided by the court, and there should be a proper hearing in which those issues are raised. The order from the Court of Appeals that the hearing would take place in the week beginning the 28th of September, but I haven't heard further details about how this has gone, so I assume that they've reserved judgment if the hearing did go ahead, and the judgment hasn't come out yet. But the parties have in fact added a new claim in relation to the further restrictions that were imposed. And this is one of the problems of challenging these regulations in court, is that by the time you get to court to challenge them, the government says, well, it's become academic, you know, that your entire legal challenge has become academic because the regulations have been superseded by a new set of regulations. It's a constantly moving situation. And so by the time you get to court, the whole scenario has shifted. I'm not necessarily of the view that the challenge is right. It's just interesting that somebody has taken this to court and somebody is asking questions about the government's legal powers to impose the sorts of restrictions that we've seen and the manner in which it has imposed them and the balance that it has struck. If we can go to the next slide, please. One of the grounds on which the lockdown restrictions were challenged in that case I just mentioned is under the Human Rights Act. And what the parties have alleged is that the restrictions constitute a disproportionate breach of fundamental human rights and freedoms in the European Convention. In particular, and they list a number of rights that they say are affected by these restrictions. So Article 5, the right to liberty, because there were restrictions on how often you can leave your home and in what circumstances. There's the right to autonomy and respect for privacy and family life because of the restrictions on who you can visit and who you can mix with, essentially. There's the right to religious freedoms and the implied right to worship as a result of religious establishments being shut down. Freedom of assembly and the right to enjoy convention freedoms without discrimination. Excuse me. On the basis that women, for example, are disproportionately affected by domestic violence that has more than doubled during the lockdown. Finally, there's the right to Article 1 of Protocol 1, which is the right not to be deprived of property. and Article 2 of Protocol 1, which is the right to education, and that relates to the shutting down of schools. So this legal challenge is ongoing at the moment. It's actually crowdfunded, although the claimant is a businessman and has been funding the claim. It's also significantly crowdfunded. So there's a lot of public interest in this challenge and in seeing how far it gets and whether it's able to succeed. The difficulty with the Human Rights Act challenge is essentially all of these rights listed here are rights that are balanced, that they're not absolute rights. So the right to freedom from torture, for example, is an absolute right. Under no circumstances can you restrict the right to freedom from torture. But many other rights, like Article 8, are rights where the state is able to restrict the rights, as long as it has a legal basis to do so, and as long as that restriction is proportionate. So this is where what the nature of the challenge would be, is to say these restrictions are a disproportionate breach of our fundamental rights. But essentially what it's asking the courts to do is to re-guess, essentially, the government's judgment, so to test the government's judgment on what is actually required, what's necessary, what's essential in the midst of a global pandemic. And I think it's very difficult for the courts, without a glaring error, without a complete howler somewhere in the analysis, to step in and say that the democratically accountable government, with all scientific advice that it has access to, got the balance between individual freedom and the public interest wrong. And I think that's where we're likely to see a challenge like this fail. But it does raise some very interesting moral, ethical, philosophical, political, constitutional questions about the current balance that we are striking as a society between individual liberty and individual choice, and collective rights and collective interests. If we can move on to the next slide, please. If you're interested in further on these sorts of issues, there's an interesting article that is publicly available by a barrister called Tom Hickman. It's called The Use and Misuse of Guidance During the UK's Coronavirus Lockdown, and quite a good Twitter account on just basically explaining some of the lockdown restrictions and rules as they come out. Is Adam Wagner, who's another barrister at Doughty Street Chambers. And if you just need a quick check, again, without maybe a clear distinction between rules and guidance, then the BBC's what are the rules in my area, I thought was quite a useful tool. If we can go to the next slide, please. So I'm moving to a completely different topic and a completely different area of my practice. I wanted to touch quickly on how the COVID-19 pandemic might affect obligations, contracts that parties have entered into, me to this bargain in these circumstances. So I wanted to touch just briefly on what some of the principles of frustration of contract are, and then if they are relevant, then there's something that might warrant further exploration, further investigation with a lawyer, if relevant to someone's circumstances. So frustration is basically a legal principle that treats the contracts as essentially being cancelled. So the courts, the law no longer holds the parties to the bargain that they made. And frustration will occur when an unforeseen event outside the control of the parties takes place. And so if it's something that one of the parties has caused, if the change of circumstances came about because somebody did something, you can't rely on frustration. But something like COVID-19 is arguably an unforeseen event. It depends at which date you entered your contract. Had China notified the World Health Organization by this point or not? also what's unforeseen is the level of restrictions that we've seen. So that the lockdown rules that have been imposed, that's part of the picture that would be the unforeseen event outside the control of the parties. The impact of the unforeseen event is that it makes the contract either physically or commercially impossible or illegal to perform, or it transforms performance of the contract into something so radically different from the intended purpose that it would be unfair to hold the parties to their obligations. So it needs to be so radically different to what you agreed to what the nature of the bargain was, that it would be unfair to hold you to that bargain. If it's only more costly or more difficult, that's not enough. It has to be something that strikes at the very root of the contract. And what I've referred to here is the case of Canary Wharf and European Medicines Agency, which Miqdad mentioned in his kind introduction, was actually a case that I was instructed in. And in this case, the High Court was concerned with the question of whether Brexit, being the unforeseen event in the circumstances of that case, whether Brexit would frustrate a lease. And in that case, the European Medicines Agency, which is it's an agency of the European Union, was renting a building in Canary Wharf, and it wanted to argue that Brexit would frustrate its contract with Canary Wharf because it had to move, and it moved to Amsterdam as a result of Brexit. And the court held that it didn't frustrate the contract because although Brexit itself was on, that particular lease on its terms envisaged that the European Medicines Agency may one day leave and had already regulated what happens in those circumstances. Could we please go to the next slide? So the steps of the process considering whether available in any particular case involves asking first, the starting point with a contract is always the terms of the contract itself. The fine print, it's time to get out the magnifying glass and actually read the agreement. Does the contract itself have a force majeure clause? A force majeure clause is a clause that says basically what happens in unforeseen circumstances. What happens if there's a war, a storm, or something that changes the nature of the contract? So if the parties have already essentially apportioned the risk between them, if they've already said, look, if this all goes pear-shaped, you take on the risk, then there's no space left for frustration because they've already divided the risk between them. Frustration only available when it's unforeseeable. If we move on to the next step, if the event was unforeseeable, did it make the obligation impossible, illegal, or radically different from the original obligation? I'll give you just one example here. Leases can have a positive user clause. They don't always have only negative user clauses. And what I mean by that is a negative user clause will say something like, you may use this building as an office, but you may not use it as something else. You may not use it as a accommodation, or you may not use it as a shopping centre. A positive user clause says you must use this building in this particular manner. Now, if you entered into a lease for a particular period of time and it has a positive user clause that says you must use this particular building as a high-end restaurant, because that's the image that we want to maintain for this particular building. And then the lockdown restrictions came into force and they said that restaurants must close. It's now illegal for you to operate the lease in the manner that you promised under the contract to do so. And so it's become illegal for you to implement the contract that you agreed to. So that we're talking about that sort of level of illegality. Where money has already been paid under the contract, there's statutory provisions that provide that it has to be paid back, subject to deducting some expenses, or if you are the one who paid money, then you have to be repaid. So nobody wins if the contract is frustrated. It's not supposed to create a windfall for either party. It's supposed to just essentially remove the bargain that you entered into, because it's no longer fair to hold the parties to the bargain. But given that so much is at stake, it's normally possible to renegotiate the terms of the contract in such difficult circumstances. And so negotiation and alternative means before taking a step as drastic and contract has been frustrated is always worth pursuing. If we could go to the next slide, please. So just to sum up, really, what the things that the court would be looking at in such a context would be the terms of the contract. So exactly what does the contract say? What risks does it apportion between the parties? What circumstances does it envisage? The court would look at the parties' knowledge, the parties' expectations, and then the parties' ability to perform the contracts in light of the restrictions that have been imposed. If we could go to the next slide, please. So I've just very briefly touched on here in this slide on some of the government guidance in relation to landlords and tenants at the moment. And it's simply to raise the issue that just because we're talking about such drastic consequences in the post-COVID-19 world, it's not to say that parties won't be held to most of the agreements they've entered into. Anybody who has read cases on frustration would know that the courts are very, very reluctant to find that contracts have been frustrated, and in fact have upheld contracts through wars in the past and through very drastic, unforeseen circumstances. But the government has introduced a number of very limited legal obligations in the context of landlords and tenants. And I'm not a landlords and tenants lawyer, but I've just flagged some of those things from the government's guidance on its website. But essentially the 6 months notice period for the notice period for evictions has been extended to 6 months notice. So tenants must be given a longer notice period for evictions at the moment. There's a winter truce in relation to evictions between the 11th of December 2020 and the 11th of January 2021. And that means that bailiffs wouldn't be seeking repossession of homes within that window. And some banks have agreed to give up to 3 months payment holiday in relation to mortgage repayments, including buy-to-let mortgages. It's not an automatic entitlement, so one would have to apply and show why it's needed. And further advice is available from moneyadviceservice.org.uk and ukfinance.org.uk. I mean, I'm sure you've all seen that there are swathes and swathes of guidance online and help. Sometimes it takes quite a bit of time to wade through, but there really is quite a lot of advice out there in different areas of life that have been impacted by COVID. Just to go to the final slide, I think. We've got other helpful resources. So other helpful resources. The ACAS website is normally really helpful for employment-related inquiries or queries. As I mentioned earlier, unfortunately, I couldn't have help from an employment lawyer, which I thought would be quite helpful in the current circumstances of having somebody who understands impact on employers and employees. But I found the ACAS website seemed really helpful on that. And self-employment income support scheme, the government has also printed some guidance in relation to that and has extended the scheme, as some of you may be aware, all the way up to April 2021. Could we just check? I think that is my last slide, but I'm not, yeah, that's it. So I've finished just in time. Can I just take a 30-second break before we go to questions and answers? I can hear my daughter outside the room. So I'm just going to take a really quick break. I'm going to switch my video off for about 30 seconds and I'll be back. Sorry about that.
No problem.
Thank you.
No, well, thank you very much, Zahra, for that talk. And anybody who does have any questions, please feel free to ask them either on the chat here on Zoom, or on the chat on YouTube, or alternatively, you can ask directly. Just put your hands up and we'll unmute you, or otherwise. So we're just putting, if anyone does have questions, please do feel free to ask them. This was obviously a talk by an expert on the topic, and there are very few at the level that Zahra is, so please do ask any questions if you do have any. We've had one through, but if others have them, please do send them through. Yeah, just a couple of. Great. Whilst we're waiting, let's just, I think it's worth just sharing some of the programs that we have here at Mahfil. As you're aware, many of our talks are restricted in some sense because of the pandemic, and we're not doing things live in person, but we are doing things online. And for example, every Sunday we have tafsir classes at 9 a.m. with Sheikh Bahmanpour, again via Zoom, tuition via Zoom on Sunday morning at 10 o'clock, Dua Kumail via Zoom on Thursday evenings, and then obviously our Friday program. Next week's program actually has just been cancelled, so we're finding an alternative for it. But the week on the 1st of November, we have our Milad Nabi program with Imran Ali Panjwani speaking, so please do attend that. The week after, we have Ethics of Following the Exemplar of Mercy of the Prophet, Professor Sajjad Rizvi the week after. And then the week after that, on the 13th of November, we have Racism in the Public Space by the famous Nels Abbey, who will be speaking on that topic. So please do participate in our programs in the various natures, whether it's the Sunday Sheikh Bahmanpour Tafsir class, the tuition class on Sunday mornings, or whether it is the whether it's Dua Kumail. We also have Husseini Madrasa, which continues during this period. Right.
I'm back.
Okay, fantastic. Can we see, are you on? Can we get your image up? Is your video on? There we go, perfect. Great. Let me ask the first question that we have. Here we go. Sorry, this is, okay, so this question has no right or wrong answer. Would you want us to have another lockdown, and if so, why?
Would I want us to have another lockdown? I would hope that we wouldn't need one. Of course, I don't want another lockdown. I'm not a scientist, and I don't purport to know what we need from a public health interest point of view. You read all these reports about a circuit break, lockdown being necessary. If that's the view that's taken, then essentially that's the view that's taken. What I was addressing essentially in my talk is having sufficient respect for the public and for the electorate to convey the rules clearly, and to draw clear lines between legal rules that they're bound to follow, and guidance that they may choose to follow, and allowing them to make choices where there are choices to be made, allowing those people to make those choices by being clear and frank with them.
Thank you. The next question is, do you think that there is a trade-off between having to get regulations quickly out in a pandemic and dealing with the reality that we're in right now, and therefore not being able to deal with that?
Yeah, absolutely. So what I referred to in passing when I was talking about the use of the emergency procedure is that when the regulations were first imposed, I don't know if you remember, but I think a week before the regulations were imposed, or 2 weeks before, there was a press release in which the message we got was one of, kind of there will be a peak at some point, and we'll have to flatten the curve at some point, but it's not imminent, it's not immediate, and there's no sort of immediate need to impose any draconian measures. And things turned very quickly. You know, within 2 weeks, we were in a full lockdown. And so clearly, when the government has to move that quickly, and when the public health risk necessitates moving that quickly, then the government, that's what the emergency procedures are there for. They're there to enable the government to take swift action when necessary. And that's why we saw just cooperation from other politicians. You know, even the opposition, everybody within Parliament didn't hinder any of the regulations that were brought in at the height of the first wave. The problem I think we have is then it seemed to then turn to just the go-to in relation to the pandemic. And yes, the pandemic is ongoing, but the nature of the regulations is that they're not always urgent. And sometimes the government spends a lot of time on Twitter explaining the regulations that will come into force. It will issue various bits of guidance, but the regulation takes another week to be issued, to be made. So the legal regulation takes another week to be made and laid before Parliament. And that sort of delay seems entirely unjustifiable. So the rules kick in, and then the regulations laid before Parliament a few days later. And it sort of seemed to get to a point where it felt a bit capricious almost. It felt like the government just no longer respected the need for Parliament to be expressing on view on law before it becomes law. And the example I gave earlier is when you're moving away from so when you're easing restrictions, there can't really be urgency there, because you're not trying to prevent people from doing something dangerous. You're in fact easing the restrictions. And yet the government was still introducing those sorts of regulations through the emergency procedure. I think one of the reasons we need scrutiny and we need to hold the government accountable is also there's a broader picture. You know, COVID-19 isn't the only challenge we're facing at the moment, and it isn't the only challenge that's going to require quite a lot of ministerial rulemaking. What we have around the corner as well is Brexit, as you all know, and much of the legislative framework around Brexit is skeleton, what we call skeleton statutes, basically. So statutes create broad rulemaking powers, and they confer those broad powers onto ministers to then go away and make regulations. And I think what is happening at the moment is an erosion of public trust in ministers' ability to respect the bounds of their power and to issue regulations, you know, strictly within the legal limits that have been conferred on them, and in a way that respects the rule of law.
Thank you. Okay, now we've suddenly had a deluge of questions, which is great fun. Let's start with this one from Ja'far al-Rikabi. At a global level, with public debt, the World Bank and IMF have negotiated with the G20 a debt service suspension initiative for low-income countries. Is there any legal precedent for suspending interest payments on private debt during crises like this for low-income families and small businesses, so they can have a bit more cash during hard times?
I'm afraid I don't know. That's the short answer to Ja'far's question. I mean, the Treasury has extensive powers, as we can see. You know, the Treasury has been looking at how it responds to the pandemic, and the Bank of England, in turn, has been looking at how it responds to the pandemic. And between them, you know, they have extensive powers. But I don't know if there is a precedent for that.
Okay. Can
ask Ja'far to ask me something I don't know the answer to.
Fantastic. Okay, good. Let's ask. So the next question is: can fee-paying schools and nurseries enforce payment if they're forced to close by the government if it's in their terms and conditions?
Yes, is the short answer. So you know, it's difficult, obviously, because that takes me back to frustration. You know, it's a sort of fancy term, but you've entered into a bargain with a fee-paying school in which you're paying a sum of money for them to educate your children, and you would think that implied in that bargain is that your children would physically leave home, go to school, and they would receive their education there. And it feels like you're getting a much worse bargain if they're sat at home on a laptop that the school has given them, or a tablet, receiving lessons. I mean, if the school fails to provide any education, you know, if they just simply say there's nothing we can do, which isn't the case at the moment. They are, when schools do shut down due to the pandemic, they are continuing to provide education, not as good an education as what you bargained for, but you're still getting something for your money. And in those circumstances, and in particular, if that actually included a clause that says you have to carry on paying, then you are probably legally bound. I mean, you would have to read your contract. That's sort of my first and primary piece of advice in relation to anything to do with a contract, is sit down and read it from, you know, the first clause to the very last clause and see what it says. But, you know, as a general position, you probably would be bound by that contract.
Thank you. Zaid, can you unmute yourself and ask your question?
Thank you so much, Miqdad. Thanks so much, Zahra, for a very interesting talk. I'm a doctor in an NHS hospital, and one of my colleagues died after contracting COVID-19, even though he was raising concerns about PPE. Can his family, I think he automatically gets 60,000 compensation. Can his family say, well, actually, we want £5 million compensation and take the government to court?
So I think, I mean, it's not something I can advise on off the top of my head, but what would be worth exploring is if there's a breach of duty in that context, if the government acted negligently, which is what people have been saying in the sort of public discourse on PPE, is that there has been some breach of duty in relation to protecting employees. So there's both the trust itself obviously has a duty towards its employees as an employer, but then there's a broader sort of Article 2 under the Human Rights Convention, so the right to life. And what you have to investigate is that the government has positive obligations to protect life. It doesn't just have negative obligations not to kill people, but to a certain extent, it has a positive obligation to protect life. And so there might be an inquiry there as to whether it's taken enough action, but it's something that would require much closer examination. And I think it warrants investigation. It definitely warrants talking to a lawyer and seeing if there is a claim that could be established that the trust is in breach of its duty, and there's a broader government obligation that's been breached here. But, I mean, sorry that I can't give it's not something I've thought about, so I can't give a more helpful answer, but it seems to me that there's definitely something there that's worth exploring about whether enough was done. I mean, what the difficulty with a case like that ultimately will be in establishing causation. And what I mean by causation is that you need to be able to establish that the breach is what caused your loss. In this case, you obviously have a loss of life, but the government's response will be, this is all, you know, incredibly tragic. We did absolutely the best we can, but in any event, you know, everybody, even with the best PPE in the world, you know, there was a risk, and you can't prove, you know, it's very difficult to prove that any particular individual caught COVID at work rather than in the supermarket or at home or through some other means. And so I think I see the challenge in those circumstances probably being less a question of whether you can establish duty of care, and more a question of actually establishing that on the facts the government didn't do enough, and that on the facts it was this thing that killed the particular doctor rather than something else. But I'm really very sorry that that your colleague died in those circumstances, and I think it's appalling that not everything seems to have been done that ought to have been done.
That's great. Thanks so much, Zahra.
Thank you. The next question from YouTube from Mohammed Khalil Jaffer. Do you think that regional and local authorities like Liverpool and London's mayors could consider the government's regulations to be a frustration of their ability to provide adequate infrastructure and care?
I mean, that is a very difficult question, because it depends very much on the structure of power, essentially how power is delegated between the government and the mayors. It's not something I've looked at, so I don't know if sorry, I sound like such a lawyer this evening. I don't know. But I mean, the difficulty is that obviously we have there are various ways in which power is divided between both central government and the devolved administrations, as well as then on a council level, on local authority level. And so one would have to look in a very detailed way at that sort of division of power, whether there is something in that means they can push back against central government. But we also live in a country where essentially Parliament is sovereign and likes to behave like it is sovereign and supreme. Some of you may have been following the debates on the Internal Markets Bill, which is much more controversial than the COVID regulations have been. And the Internal Markets Bill is one of the bits of legislation responding to Brexit, essentially, and it looks at free movement of goods within the nations, so within the United Kingdom. It's not about our trade with other countries, but within that particular setup, Parliament has taken a particular view about what the law will look like. And what we've seen from the devolved administrations is really quite a lot of protest that this essentially takes away too much, claws back too much power by central government, powers that they thought they had been granted through certain conventions. So much of the devolved powers are conventional rather than sort of set in stone. And central government so far, Parliament so far, essentially driven by the Tories and by central government, has shown very little sympathy for those sorts of arguments, and is pushing through with legislation that's very focused on centralising essentially the internal market. So I think, you know, at the end of the day, if Parliament deems particular regulations to be necessary for the protection of the public interest, it's not going to be very concerned about what different councils feel.
Thank you, Zahra. Another question from Iqbal Asaria on YouTube. Are the different interpretations by different UK nations on the basis of the same evidence a possible way to challenge the law? For example, the rule of six, including children in England and not including children in Scotland.
So I'm not sure whether they are interpreting the very same regulation or whether there's local distinctions there, because as far as I'm aware, both devolved administrations have been imposing their own regulations. So some of the regulations apply only in England, and Scotland has been imposing its own regulations. Wales has been imposing its own regulations. I haven't really followed Northern Ireland in the current in relation to COVID rather than Brexit, and so it might be that there's in fact different rules that apply. But I think, you know, as I was saying earlier, that if a particular enforcement decision can sometimes be challenged on the basis that the rules are inaccessible and therefore unfair. It's a basic tenet of the rule of law that you should be able to understand the rules that apply to you. So if someone who's being fined or someone who's being, the reality is most people are not going to challenge a fine in court because it's too expensive and too difficult to, which is sort of what the more general public law challenge that I was referring to earlier is aiming to deal with. But if any one individual were to try to challenge it, they would say, I tried my best to follow these rules, but they're inaccessible and they don't make sense. And so they're a breach of my fundamental rights because, it's impossible for me to follow them. But I think, ultimately, until they've been interpreted by court, until there's an authoritative judgment saying this is what they mean, the fact that different people are applying them slightly differently is not necessarily conclusive.
Thank you very much. Another question here on chat. Askari, would you like to ask it directly or would you like me to ask on your behalf? Feel free to unmute yourself, and if not, in the next 5 seconds, I will ask it. Okay, so how can we stop the government extending the congestion charge zone in London and stop them removing free travel from children and senior citizens? I assume this is in the context of the government enforcing that, as you're aware. Yeah.
I don't know. It's a short answer. So, I mean, if it comes into law, you would need a legal basis for saying that decision is wrong in law. It kind of takes me to the talk I did last year, which some of you may or may not remember, about the limitations of a public law challenge. And so in the context of a public law challenge, the court isn't really there to second guess public policy. I think what people don't always appreciate in the context of sort of big political questions, like where do you draw the line? How do you give out money fairly in society? Those sorts of questions. Lots of those are actually political rather than legal questions. And, regardless of how much Priti Patel moans about activist lefty lawyers, laws actually plays a really rather limited role in this context. And it plays a limited role in the sense that public law is concerned with process. It's not necessarily concerned with outcomes, with the exception of human rights law, which does look at whether any restrictions on human rights are proportionate, which is unlikely to be relevant in the context of the congestion charge. But if the government reaches any particular political policy decision, and it reaches that decision in a lawful manner, then it's very difficult to challenge it in a public law context, because the courts are not they're not there to second guess government, and they're not there to impose they're not there to make decisions like where the congestion charge should apply, because you can't lobby the courts and you can't vote them out if you don't like them. But you can get rid of the Tories if you don't like what they're doing at the moment. And you can lobby Parliament to make sure that travel restrictions don't change. Free travel doesn't change. So I think there's an appropriate place for political lobbying, and then there's an appropriate place for law. If the government, in reaching those decisions, makes that decision unlawfully, and the sorts of public law challenges that we say that are permissible is if the government behaves unreasonably, if the government takes into account irrelevant considerations, or takes into account or fails to take into account relevant considerations, the government has a legal obligation to have regards to the public sector equality duty. And that means when it creates a decision that's going to have an impact on people with protected characteristics, if it's going to have an impact on the elderly, for example, or if we can show that a higher proportion of people with disabilities are currently benefiting from the way the transport system is set up, and they would lose that benefit if new changes are brought into place, the public sector equality duty requires is that the government has regard to that. So it's simply an honesty duty. Basically, all it does is it requires the government to look the consequences of its legislation in the eye and put its hands up and say, we know this is going to be terrible for disabled people, but we want to do it anyway for these other reasons, and then justify it. But if they actually do those things and they reach a decision lawfully, then even if we don't like that decision, it's normally very difficult to challenge it in court. And so you're looking at political means to achieve those ends rather than legal means to achieve them.
Thank you very much. Slightly off topic, but I guess related, is a question about the future of the judicial ability to hold the government to account in public.
Judicial review.
The judicial review.
Yeah. So the government has set up an independent panel to review judicial review. So what we call judicial review is what I've been talking about. It's the ability of the powers. The ability of the courts to hold public authority. So that's not just the government, it's any institution exercising a public power. So it even includes exam boards where they're exercising a public power. So any institution exercising a public power is held accountable through the courts through a process called judicial review. Most judicial reviews are actually not against the government. They're against local government, they're against different agencies. But there have been a number of high-profile cases against central government in the last couple of years, namely the prorogation case and the Article 50 case, both Brexit related, that the government really did not like losing. And since then, they've been making some noises about the courts overstepping their rightful place, and they've just announced this review, which is currently accepting evidence. It's still accepting evidence until the 26th of October. So the review is set up with a number. It's supposed to be an independent review, and it's put out a call for evidence that I've responded to through Chambers, that I've also responded to with a charity I work with called Justice. And we've responded to the different themes raised in the call for evidence, which asks things like, do you think judicial review should be limited? Do you think it should be codified? Does it strike the right balance between government and the ability of government to get on with its business, basically, as well as individuals' rights to hold it accountable? So there really is a concern, I think, at the moment, that the government is trying to interfere with the judiciary's ability to hold it accountable. And we see it through this review, but I don't know what the outcome will be of the review and whether there will be attempts to implement it. And there's been a very strong response from the legal profession explaining why it's misguided and why judicial review is fundamental to the rule of law, and it's fundamental to the idea of government by law that sits at the very heart of our constitution. But I mean, even more broadly than that, the internal markets bill that I was referring to earlier has essentially a judicial ouster clause, which is where Parliament is being used because in the UK, Parliament is sovereign. Unlike the US Supreme Court, which can strike down primary legislation, the UK's courts don't normally have the power to strike down primary legislation outside the context of EU law, which is now going away because of Brexit. And so a statute of Parliament is binding on everybody, including the courts. And so if a statute of Parliament says the courts don't have power within a particular sphere to review government action, then what it essentially sets us up for is a confrontation between Parliament, the government, and the courts. Because when the courts come to interpret that clause, how are they going to treat that that attempt by Parliament and by the government to shut them out? And that's one of the unfortunate things we're seeing in the Internal Markets Bill, is essentially wording that's not quite that stark, but it's almost that stark. Because the Internal Markets Bill has intentionally been set up to break international law and to break a number of domestic legal provisions that implement the European Withdrawal Agreement, there's then a clause within the Act itself which says that the courts are bound to find that this piece of legislation is valid and is legal despite that particular breach of law. And so it tends to control the way that the courts interpret the law and apply the law. And it's quite interesting to see, the government essentially setting itself up with for a fight with the courts. It's interesting to see which way it will end, really, whether it ends like the prorogation case and Miller 1, where the Supreme Court essentially finds a way to say that's not how it works, and you're bound by the law, and we get to say what the law is, and finding the government's conduct is illegal and forcing it to change its course.
Thank you very much. There have actually been a few more questions, but I think we have run out of time.
Yeah.
We've gone much longer, and so thank you very much. There's clearly a lot of interest in your talk and your expertise in this area. So thank you for coming, and I'm sure we'll have we will try at least to get you again next year and continue our annual series with you. So
thank you very much, and thank you all for taking the time to listen to me on a Friday night. So thank you.
Thank you. Okay. I think we'll end there. We have got talks coming up, so please look at sicm.org.uk if you'd like to find out more. Thank you very much. Assalamu alaikum wa rahmatullah.
Alaikum salam.